Regime of separation of property. Each spouse has complete control and ownership over his or her own properties, which will include all earnings from his or her profession, business or industry, and all fruits, natural, industrial, or civil, due or received during the marriage from his or her separate property. Expenses of the family shall be shouldered by the spouses in proportion to their income, or in case of insufficiency or default therein, to the current market value of their separate properties. Judicial Separation of Property. Article 134 of the Family Code. In the absence of an express declaration in the marriage settlements, the separation of property between spouses during the marriage shall not take place except by judicial order. Such judicial separation of property may either be voluntary or for sufficient cause. If the spouse did not execute a written agreement regarding their property regime prior to the marriage, they can no longer change it after the marriage ceremony has taken place unless they have secured judicial approval. Sufficient causes and grounds for return to previous regime. So what are sufficient causes for judicial separation of property? Under Article 135 of the Family Code, 1. Where the spouse of petitioner has been sentenced to a penalty which carries with it the penalty of civil interdiction. Ground for return to the previous regime is termination of the civil interdiction. 2. The spouse of the petitioner is judicially declared an absentee. Ground for return to the previous regime is the reappearance of the absentee spouse. 3. The loss of parental authority of the spouse of petitioner has been decreed by the court. Ground for return to previous regime is the restoration of parental authority to the spouse previously deprived of it. 4. The spouse of the petitioner has abandoned the latter or failed to comply with his or her obligations to the family. Grounds for return to previous regime is when the spouse who left the conjugal home without legal separation resumes common life with the other. 5. The spouse wanted the power of administration in the marriage settlements, has abused that power. The spouse granted the power of administration in the marriage settlements, has abused that power. Grounds to return to the previous regime: when the court, being satisfied that the spouse granted the power of administration will not again abuse the power, authorizes the resumption of the said administration. 6. At the time of the petition, the spouses have been separated in fact for at least 1 year and reconciliation is highly improbable. Ground for return to previous regime is when reconciliation or resumption of the common life of the spouses who had been separated in fact for at least 1 year. When the voluntary dissolution of the ACP or CJP had been judicially decreed upon the joint petition of the spouses, they agreed to the revival of the former property regime. No voluntary separation of property may thereafter be granted. Separation of property. When does it apply or when it applies? 1. Agreed upon in the marriage settlements by the spouses. 2. Mandatory under Articles 103 and 130 of the Family Code. The subsequent marriages contracted by the surviving spouse without judicial settlement of the previous property regime. 3. Judicial separation of property, voluntary or just cause. And 4. Default property regime, when there is reconciliation between the spouse after judicial separation of property. What does it consist? Or what it consists of? 1. Present or future property of or both. 2. Each spouse's earnings from his or her own profession, business, or industry. 3. Natural, industrial, or civil fruits of a spouse's separate properties. 4. May be total or partial if partial property not considered separate is presumed to pertain to ACP. Liabilities. 1. Family expenses. Both spouses are liable in proportion to their income, if insufficient, based on the current value of their separate properties. And 2. Creditors for family expenses. The spouses are solidarily liable. Ownership, administration, enjoyment, and disposition. 1. The spouses may own, dispose, possess, and administer separate estates without the consent of the other. 2. Administration of the exclusive properties may be transferred between spouses when 1. The spouse or one spouse becomes the other spouse's guardian. 2. One spouse is judicially declared an absentee. 3. One spouse is given the penalty of severe interdiction. And 4. One spouse becomes a fugitive. Third, on ownership, administration, enjoyment, and disposition is conveyance between the spouses is allowed under Article 1490 of the New Civil Code. Property regime of unions without marriage under Articles 147 and 148. What are the applicability? Or when does it apply? For Article 147, man and woman living together as husband and wife with capacity to marry, under Article 5, without any legal impediment, is 1. At least 18 years old. 2. Not violative of Article 37 on incestuous marriages or incestuous void marriages. 3. Not violative of Article 38, void marriages by reason of public policy. And 4. Not bigamous. Under Article 48, applicability is when man and woman living together as husband and wife are not capacitated to marry. Either 1. Under 18 years old. 2. Adulterous relationship. 3. Bigamous or polygamous marriage. 4. Incestuous marriage under Article 37. And 5. Void marriage by reason of public policy under Article 38. Under Article 47, in addition to the applicability, it also applies to void marriages due to absence of formal requisite. Salaries and wages. For Article 147, owned in equal shares. For Article 148, separately owned by the parties. As to properties acquired through the exclusive funds under Article 47, it remains exclusive provided there is proof. Under Article 48, it remains exclusive. Properties acquired by both through work and industry. Under Article 47, governed by the rules on co-ownership. Under Article 48, owned in common in proportion to their respective contribution. Properties acquired while living together under Article 47, owned in equal shares, since it is presumed to have been acquired through joint efforts. If one party did not participate in acquisition, presumed to have contributed jointly, if the former's efforts consisted in the care and maintenance of the family and household. Take note, neither party can encumber or dispose by acts inter vivos his share in the co-owned property without the consent of the other until cohabitation is terminated. Under Article 48, what are the properties or properties acquired living together? There is no presumption of joint acquisition. When there is evidence of joint acquisition but none as to the extent of actual contribution, there is presumption of equal sharing. Forfeiture. Under Article 147, where only one party to avoid marriage is in good faith, share of party in bad faith is forfeited in favor of their common children. 1. 2. In case of doubt or in case of default or of waiver of any of all the common children, their descendants, each vacant share shall belong to the respective surviving descendants. In the absence of such descendants, such share belongs to the innocent party. Under Article 148, the forfeiture, if one party is validly married to another, his or her share in the co-owned property will accrue to the ACP or CGP of his or her existing valid marriage. If the party who acted in bad faith is not validly married to another, his or her share shall be forfeited in the same manner as provided in Article 147. The same rules on forfeiture shall apply if both parties are in bad faith.